Okay, I am hoping we're live and people are going to join us soon. Welcome to day 2 of the NLSIR Symposium. After a very robust round of discussion yesterday on 2 panels, this is the final panel discussion that will take place today. I will let Bharat introduce the panelists because he's much more intimately familiar with their work, etc. Just to sort of recap, like for today's audience and today's panelists, um, I am not the editor-in-chief under whom this project began. That sort of thing goes, like credit goes to my predecessor, Kopal, and Bharat, who conceptualized single-handedly this entire symposium, got the curated the content together, got the authors on board, and sort of grounded it. And this board that came forward and then took it onwards. I don't think our audiences, either at NLS or the ones outside of the National Law School, need any introduction to B.S. Chimni. He is one of the leading voices of TWAIL. Priyansh, who's joining us, who's my junior, Bharat's batchmate, Bharat, I, etc. We have all read B.S. Chimni in our public international law courses. And yeah, I just really hope that it's a fantastic discussion today because we are discussing papers written by our open contributions and not the commission ones. So I'm going to hand it over to Bharat now to talk about a bit about the panelists, the symposium issue, etc., etc.
Hi. I think most people here were part of yesterday, so I'm not going over the special issue itself because I'm assuming everyone is familiar with it. And thank you for everyone who showed up today as well. I'm sure that, especially Professor Chimni and Professor Sona Raja, I'm sure your presence adds a lot to the open discussion that we have planned, which is 25 minutes of Professor Sen would be largely framing questions and having an open discussion where we could all discuss our ideas and takeaways from the symposium and anything we want to really. But before that, we'll have a panel discussion, and we have quite an exciting panel of people before us. In no particular order, we have Mr. Rongeet Poddar. And interestingly, when Mr. Rongeet had actually submitted his article to us, he was with NUJS, the National Law University in Kolkata. Now he's one of the professors at NLS, and he actually teaches human rights for the third-year batch at law school, which is quite serendipitous. We have Professor Maia, who's a senior lecturer at Oxford Brookes University. She has a very interesting paper on charting a research agenda for international law and international relations, which is the kind of conversation generators that this symposium is all about. We're quite excited to hear from you, Professor. We have Atira Raju, who is from Kerala and engages in international law research. She also has an interesting paper situating between history and war, and we also look forward to hearing from her. And we also have Priyansh Dixit, who is an undergraduate student from National Law School. And I think it's one of the only undergraduate students to publish in this issue, which is quite special. And especially as someone from law school as well, I'm quite especially happy to see that. So that is the panel we have before you. Professor Sen would be moderating the discussion, post which we'll move into the open discussion. And again, we look forward to hearing from all the panelists present here, as well as the audience in the Q&A box, both during the panel, as well as more importantly during the open discussion. Over to you, Professor Sen. Thank you.
Thank you so much, Bharat. We will move on straight into the panel. Our format remains the same as yesterday, 10 minutes per speaker. Then we open it up to the panelists for a round of conversation, exchange, discussion, and then our participants, should they have any interventions to make. We're going to begin with Atira Raju. Her conversation has great synergies with yesterday's discussion. She picks up on the theme of subaltern internationalism and subalternism as a mode of international legal personality. And she uses this to walk us through the history of the International Labour Organization. Atira, over to you.
Thank you, ma'am. First of all, I thank all those who are involved in the process of organizing this conference. Move on to my topic. Colonies and International Labour Organization of Subaltern Outlook. So we all know subalterns are the people who are in a particular society who are suffering under the hegemonic domination of the ruling elite, and they have no rights. in the realm of international law, the voice of subaltern was not even considered, or the subaltern class was not even considered as a subject for a long time. Certain post-colonial legal scholars made efforts to make the class visible. So this incapacity of international law to encompass the diverse nature of societies and of the people has been critically evaluated by the post-colonial legal scholars, and they opposed the elitist dominant class language of international law. However, the post-colonial scholars, they failed to reclaim the subject from the European hegemony. They oppose the imperial nature of international law, but unfortunately, they failed to displace it. Like Chimni calls international law as a double-edged weapon. It is an instrument of subjugation and also of liberation, of exploitation and possible emancipation. So this paradox of international law demands adjustment from the part of post-colonial legal scholars. Because the whole premise is based on the argument put forward by Chimni, that is the instrument of subjugation and of liberation, exploitation and possible emancipation. So he claims that the reconstitution of the relationship of law and periphery has to take place from within the prison house of international law. So this duality of international law can be best explained from the transaction of International Labour Organization, because International Labour Organization has shown this duality throughout its life. But this paper is very limited to the interwar period only. So it gives an historical account, and I'm focusing only the transaction that has been done by the International Labour Organization during the interwar period. So my major focus revolves around Article 35 of the original constitution of the ILO that deals with the colonies, or it has been the Article 35 of the constitution has been called the colonial clause. So it's all start with the appointment of Commission on International Labour Organization, Commission on International Labour Legislation in the year 1990. Since its inception, since the drafting stage, we can see the duality of International Labour Organization, how it deals with the labor matters. Because we always say that the International Labour Organization is a face setter of international labor interest, but it has another phase that when it deals with the colonies. So the whole thing starts with the Commission on International Labour Legislation for drafting this constitution of ILO. So the commission was mainly composed of the 5 great powers and other powers who are elected by the members of the peace conference. The commission mainly based their discussion on the British proposal, though other propositions from other representatives were also taken in account. They majorly they based or they followed the British proposal. So coming to colonies, the British proposal has an article called Article 35. So it deals with self-governing colonies and non-self-governing colonies, which we can see in the ILO constitution also. So, but in the proposal that was submitted by the British version, it mentions that the British dominions in India and also the fully self-governing colonies or possession of other powers shall have the same rights and obligation under this convention as if they were separate high contracting party. So the self-governing colonies, British dominions, and India have the same rights and obligation as that of the high contracting parties. But in the case of non-self-governing colonies, possession or protectorates, the application of the convention could be decided by the mother country. But again, against this proposal, Belgium has raised an argument that even in the case of self-governing territories, they have to procure the consent of the mother countries. And in the case of non-self-governing territories, other delegates, majorly the imperial powers, urge that they require, that is, a reference should be made in the conventions that is going to be adopted in the future. There should be an express a reference stating that an express decision of the mother country for the application of labor convention in such territories is needed. However, we can see a disagreement from the part of France, that France opposed most of the proposals submitted by the Britishers and Belgium and other. And France, the delegate of France noted that reference to colonies itself means you are putting the colonies in an inferior position. The commission just want to put the colonies in an inferior position and to deny the working class of colonies the purpose of international labor legislation. So the disagreement was from the part of France. But the British delegate was very adamant, he was stating that the wider application of international labor legislation and labor convention would be difficult for countries that have numerous colonies, because Britain that time has a number of colonies with them. So he argued that such a situation would cause a burden on the mother country. That was a discussion part. So after taking all the varied views, they came into a conclusion that they will adopt that Article 35 was adopted in such a way that it gave the self-governing colonies, British dominions, and India have they enjoy the same rights and obligation as that of the other high contracting parties. Whereas in the case of even in the case of self-governing territories, that is the draft constitution of ILO says that even in the case of self-governing territories, it should be recognized by the Executive Council of the League of Nations. And in the case of non-self-governing territories, colonies, protectorates, and possessions, it is subjected to an exception. That is, the application of International Labour Convention is subjected to exception that the convention can be made inapplicable if the local conditions of the colonies pose a hindrance to such application, or the mother country can modify the convention to make it suitable for local condition. That was the criteria applicable to non-self-governing territories. That is, either if there is the local conditions are not permitting the application of the convention, then it is not permissible, or the mother country has the right to modify that convention and make it applicable to the colonies in the case of non-self-governing territory. So here in the Article 35 itself, we can see that compromise of two approaches. Note in the Article 35 that on the one hand, the ILO has adopted measures not only to improve the labor conditions in the sovereign state, but also in the colonies. The exception clause is problematic. They said that, it is inapplicable if the local conditions are not permitting. So the ILO played a very restrictive role in attributing responsibility to imperial powers for the automatic application of ratified convention. Here, Maud argues that nowhere then was the European bias of the ILO more pronounced than in the field of colonial labor. So it was unsurprising to learn that the constitution of ILO is a reflection of the interest of imperial powers. Moreover, the economic interest of the imperial powers were conspicuously present throughout the proceedings of the commission. The economic interests governed the whole proceeding. They were more not about the interest of laborers, but more about the interest of the power, the imperial power, their competition. They just want to restrict the competition between them. That is why they included all this, or they came up with the idea of International Labour Organization itself. So this Article 35, we can see in almost all other conventions until the Second World War. But this Article 35 has been barely used by any of the countries because any of the convention has not been, no convention until the Second World War has been applied in any of the colonies. But even if it was applicable, it was modified. As you can see in the case of especially in the case of child labor, the minimum age. It is very interesting that to see that the contradictory approach of the ILO from the minimum age convention, because okay, thank you. The minimum age for child labor, they fix the minimum age for child labor. The ILO fixed the minimum age for child labor, but on the other side, it allows its imperial member countries to continue child labor in the colonies. The colonial power had taken no steps to apply the minimum age convention in the colonies, since it would prevent them from employing children with low wages. Britain's argument was that to exclude colonial child labor from the application of the convention was that they argued that the children in the tropical climate matured early and therefore could render their labor from a younger age than children from the European side. Similar arguments were also raised by other imperial powers. So this is the colonial powers, how they responded to the convention and how they step back from applying the international labor conventions in the colonies. So this duality of international law, the real reflection of that duality can be seen in the transaction of international labor organizations. Thank you.
Thank you so much, Athara, for that very rich doctrinal historical work on the convention and the article. You illuminated a different function of jurisdiction, which is the ability to dictate the terms of law as well. And there are interesting parallels with Vasuki's paper from yesterday, this kind of temporal simultaneity where the same law that is looking to criminalize certain conducts is equally color conscious in what it criminalizes and what it doesn't. Thank you so much for that. We will now move on to Dr. Pal, whose paper I am quite excited about. Dr. Pal has, of course, spoken of the significance of Professor Chimni's theoretical and methodological apparatus that has cross-disciplinary value as between international law and IR. And she's extending the extraterritoriality argument in this specific paper to the computational infrastructure, as you call it, namely gig economies and data technology, and how the control over these sites, while they produce new challenges, they're also framed by the old imperial patterns. So over to you, Dr. Pal, and looking forward to your paper.
Brilliant. Thank you so much for this invitation and for organizing. I understand it's a lot of labor for all of you going into this organization. So I really want to thank everybody and for this opportunity. So I'm going to talk a little bit, hopefully I'll get to the point about computational infrastructures and the more contemporary aspects, but I do want to spend quite a good part of my talk to come back to the contribution of Professor Chimni's article and what it means and what we can do with this contribution on a theoretical level. So I think it's really important to emphasize that and spend a little time on this, and then I'll talk about how I try and apply it in a more contemporary context. So in my reading, Professor Chimni's argument is based on more an international relations or maybe international political economy analysis of international law. The focus on the two logics, territory and capital, and their genealogy in the formation of the modern state system is, for me, a political and economic analysis of the creation of the international legal order. And I'm not saying this because I want to discipline the text as an IR text, but more because I think, well, firstly, as any good Marxist approach, it is inter or cross-disciplinary, and I think that's really comes across in the piece. But the real reason I say this is because I want to emphasize this relationship between international relations and international law, which I think is refreshed by the text and provides the basis for a new encounter, which is very necessary. Both disciplines need to be constantly reminded that they are joined at the hip in complex ways historically, but they often try to act as if they're not, and especially the mainstream, I suppose, aspects of both those disciplines. So the critique of mainstream international law that Chimni develops in the article could be applied to international relations as well, right? This focus on territoriality and the nation state, and this erasure of how capital shapes that process is something that is perfectly applicable to mainstream international relations as well. And that critique is not new either in many ways, but it still needs to be voiced very loudly, especially as we enter, or we're very much in periods of kind of global geopolitical conflict, and the more narrow-minded state-driven analysis just pour out into the media and even in intellectual circles, and you know, all the critical heads are like, no, but no, don't just jump into the game theory state approach. So I think it's really important to continuously remind these disciplines, the mainstream parts of these disciplines, that there are other ways of doing analysis. So I really want to take seriously Chimni's critique here in terms specifically how it's centered on the concepts of jurisdiction and extraterritoriality, what this can do for IR and international law, how it can renew their necessary academic encounter. And I think the angle of jurisdiction and extraterritoriality is one that critical approaches in IR have not taken, and therefore I think this is a new contribution that they should take on. So this is hopefully this will be something that IR will listen to a bit more. So what I see in this argument is a theoretical move to conceptually extract or isolate the specific practices of jurisdiction and extraterritoriality from the broader order or system of international law and international relations. This extraction or isolation of this practice enables a dialectical contribution that highlights two processes. So the first process is that it acknowledges and traces the unequal power relations and the colonial hierarchies inherent in modern jurisdiction and extraterritoriality, right? This is what we discussed yesterday, and the Chimni's definition of extraterritoriality is the power of advanced capitalist states to influence and shape the standards, laws, and institutions in other jurisdictions, or as he said yesterday, the dominated states. But the second element that's also important, and again, we've been touching a little bit on this, is opening up space to think implicitly about jurisdiction as a technology or as a process of resistance or subaltern internationalism. And you know, these are not my words, and I would potentially be more cautious, and maybe I would introduce here the Foucault's concept of counterconduct. So a form of resistance that is subversive, that can be very effective in many ways, but does not fundamentally threaten or dismantle the system or expected conduct in place. And I'm wondering if that maybe can be linked to what Professor Sorna was describing yesterday really usefully in terms of defensive extraterritoriality, right? Whereas the first element I described, kind of the power, the unequal power relation, is the more offensive side. So I thought that was quite interesting to maybe bring together. So for me, the contribution of the article is more theoretical than historical, and I may be a bit pushing on something here, because I think Chimni yesterday was saying that it was a historical project, and it is, but I think, as he also said, it's all about the present, right? It's a historical project about the present, and therefore it is more important. And I have some issues historically, but I don't talk about this in my written paper, and I don't, you know, Q&A, maybe we can have a debate about the emergence of the nation state, the modern state and capital, but that's, yeah, I don't think that's very important. Theoretically, I think this is a political economy of jurisdiction with extraterritoriality as a mechanism that reveals the dialectical contradictions of this jurisdictional process in our history. And I think that is just a fundamental project. And I think, you know, I've been trying to work on this, and the way that Chimni clearly and forcefully has been able to lay it out in this article, I hope is going to really resonate and start something new. So I did really want to spend some time on this today. And this jurisdictional process is about the expansion of power, it's about the exclusion of power, it's about the bordering, the slicing, the overlapping of power, and it's about forgetting sovereignty, forgetting territory, and really focusing on jurisdiction, because jurisdiction reveals the actual establishment of authority, right? The strategies used to create, maintain, and even sometimes resist the legal hierarchies of our order. And the obsession in international relations with sovereignty is only the end process of that establishment. And that's what fascinates me with jurisdiction, is that it actually really tries to look at how we got to that end process, right? I mean, there's obviously been a lot of work on this already, but I think we need to go on, continue developing that and applying it in different ways, right? How did we actually get to sovereignty? How did we get to that established order of disorder and inequality, right? So I don't know how much time I have left. I forgot to look at the time, but hopefully I have a few minutes to sort of show how I can apply this now a little bit to a contemporary context. And so in the written piece, a very short written piece for now that I'm revising and hopefully will add to is to reveal a little bit more the relationship between jurisdiction, capitalism, and imperialism today, right? And how we can use this this device or this project that Chimni puts forward through this triad. So rather than focusing on sovereignty and territoriality, we focus on jurisdiction, capitalism, and imperialism as a sort of a new method in a way to understand what is going on and the structures, the mechanisms today. So I've been looking at aspects of the digital economy, and I'm still at the beginning of this project. So please send me any comments to help me on this. What I'm trying to do is I'm trying to trace the old imperial logics of the 19th and 20th century and I think the previous presentation was really useful in this regard, how they resurface in the infrastructures of the latest phase of capital accumulation. Which I think we are very much still in capitalism. So I talk a little bit about these debates on techno-feudalism, but I don't buy that. I think we are very much still in capitalism. So this recent phase of capital accumulation, I think, is more and more relying on one aspect, one infrastructure, which is undersea cables. And these cables maintain between 94 and 99% of all telecommunications. They're a massive infrastructure. And the two European hubs are, surprise, surprise, in the UK and France. And so it's been really interesting to see. I'm hoping to find out a lot more and digging into these cases in terms of how these states develop these cable landing sites and develop them as hubs and become dominant in these new technologies and these new ports or hubs of communications. And a recent report by the Suboptic Foundation, which is an academic industry partnership supported by the University of Cambridge and the Canada Research Chairs Program, states how generally these cables are branded as sustainable. They provide, and I quote here, opportunities for reduced travel, more efficient access to information, enabling international climate-related science, and they underpin social and economic fabric of our world through global communications. So the report also says that we need to improve the sustainability of these projects, etc. But I think generally there's a real need to actually establish the inequalities that cables reinforce. The power relations at the origins of the ownership and development of these cables needs to be challenged. So most of these cables are owned by US companies with some Chinese competitors, big tech companies usually. And what's interesting is the jurisdictional void, and I'll finish on this. I'm not sure how much time I've got left, but I imagine not much. But there's a jurisdictional issue here in terms of who owns these cables, right? And so these cables are owned by private companies, but there's the partnerships with states over the cable landing sites, the development and the maintaining of these cable landing sites, I think is really interesting. And this, it's been called a gap. I mean, Sarabi Ranganathan talks about the liminality of these cables, right? So there's a lot of interesting work going on already about this. But I think we need to think more in terms of how also the states are using these to develop or to reinforce, to renew their imperial hold on specific aspects of capitalism. So I'm trying to look more into this specific jurisdictional void that states are taking advantage of in many ways, right? And the new economic blood that they can suck from these technologies and these infrastructures. So I'll be looking at these ports, these hubs in Butte and Marseille. So that's what I also describe as jurisdictional accumulation. I won't go into that. So happy to answer more about that. That's my old work, but I'm trying to think about in the contemporary context how this can be applied. So thank you very much. I'll leave it there.
Thank you so much, Dr. Paul, for that very, very illuminating account. We do have questions on jurisdictional accumulation. We'll come back to it in the Q&A. and also for reiterating the theoretical significance and heft of both Professor Chimni's work and your own, and why these are approaches, tactics, techniques, and methods that should be taken forward, especially in the context of the kind of challenges we encounter today. Our next presentation, actually both the presentations that follow, do a demonstration of these methods and approaches. The first presentation is by Rongeet Poddar, who walks us through interesting heuristics of 3 human rights treaties, 2 in the post-war era, and 1 a more recent intervention principle to show us how the neocolonial patterns emerge again. Rongeet, are you all set?
Yeah, I hope I'm audible. Yeah, so yeah, a very good evening to everyone, and I'm very thankful and grateful to the organizers for putting together this wonderful symposium. Right? And I'm also grateful to the guest editors, Professor Sain and Professor Keepner, for uh, the extensive feedback which you've given, which has helped me revise and come up, reflect and come up with more ideas for the purpose of my piece. Right? So in my piece, I primarily look at 3 couple of post-war instruments, which are the ICCPR and the ECHR. Right? I look into the kind of jurisdiction clauses which they have. I look into the rights derogation clauses which were also provided for. And then finally, I turn my attention towards the responsibility to protect, or R2P as we know it, which I feel is a new kind of jurisdictional internationalism, which is emerged, right? But as far as the primary thesis which I've advanced in my paper goes, I have argued that the idea of jurisdiction today with the emergence of R2P goes well beyond effective territorial control, but can now be envisaged as a form of responsibility, right, with R2P. So jurisdictional internationalism is very much something which I feel is there to stay, right? Uh, for the frame of my analysis, I have incorporated genealogy, the idea of genealogy as the methodological approach, because I feel that genealogy helps us transcend the typical positivist and technocentric understandings of jurisdiction within mainstream international law discourses. And genealogy as a mode of critique, it is something which is very much situated in the present, but it is also at the same time sensitive towards the past trajectories, right? So it's a novel form of critical inquiry, which I feel is beneficial in in any TWAIList analysis of international law. Right? And genealogy helps us unpack the neutral rules or conditions of the present, which are in a way molded by certain past contingencies like colonialism, right? So the genealogical approach helps us cultivate an awareness uh, with regard to the colonial continuities, which are very much there today. And it also helps us imbibe a sense of suspicion about the colonial continuities which are there. So in effect, the idea of genealogy goes beyond its literal meaning, which is to trace a line of descent, right, for the purpose of locating a pedigree or for celebrating the origins of a doctrine. That's not something which genealogy is, right? What the genealogical approach rather does theoretically is to question the normativity at the heart of mainstream international law, which has been kind of naturalized or been made to appear inevitable, right? So it helps us. It helps us make visible the entrenched anomalies, like the colonial continuities, which I've incorporated in my paper, right? So to conclude with respect to my the frame of the methodological frame which I've adopted, I think genealogy has a therapeutic impact, right? It kind of provokes us, therefore, to unearth new possibilities and challenges the originary hierarchies of international law, right? And I have significantly relied on Kate Parsons' paper in the Leiden journal, where she introduces how genealogy can be a beneficial tool for critiquing international law, and I must refer to how she describes genealogical inquiry as throwing up a set of processes and contingencies that are steeped in blood, right, and not necessarily celebratory of international law. Moving on, I must now turn my attention to the drafting history of the UDHR as well as the ICCPR, which are predominantly the two instruments which have adopted as a couple of heuristic devices for to unravel the entrenched coloniality, which has kind of shaped the trajectories of jurisdiction. And there was a significant debate with respect to the formal application of the UDHR to non-metropolitan territories, which is again a euphemism for the colonies, right? And the communist bloc of states led by the Soviet Union wanted an explicit mention of the fact that the UDHR must apply to the colonies. Even states like Yugoslavia, for instance, proposed a separate clause allowing for the UDHR to be made applicable to populations of trust as well as non-self-governing territories. And obviously, the state representatives of the UK before the Commission of Human Rights was not too pleased about this, right? And the argument which is made by the UK is that such a distinction was unwarranted. And later on, there was a proposal coming in from Egypt, right? The state representative of Egypt, which ultimately led to the inclusion of this phrase in the preamble of the UDHR, the fact that the UDHR is applicable to people of territories under the jurisdiction of all states, right? And with respect to the non-discrimination mandate in the UDHR, we will also see that with Cuba's intervention, right, the mandate of non-discrimination was interestingly extended. It was a debate for the third committee for positive time. I will not get into that debate here. But so, and Cuba had proposed that no distinction should be made on the basis political, jurisdictional, and international status of a country when it comes to enjoying the UDHR rights, something which is ultimately incorporated. So what the UDHR broadly has done with its preamble and the scope of the non-discrimination clause is that it ultimately gave rise to the possibility of a binding international human rights instruments to be made applicable to colonial territories. So it kind of highlighted that is indeed a possibility, right? Which was later on, of course, the hopes of having such an instrument were belied. And that is where I'll get to the ECHR, which is the European Convention on Human Rights. And so the semblance of formal equality, which the UDHR provided by virtue of its preamble and Article 2, that was completely dismantled in the ECHR because it adopted this discretionary territorial application clause, which we find today in Article 56, at that time in Article 63, the ECHR was adopted. And we will notice in this territorial application clause how the term colonialism has been very carefully effaced. I would say strategically it's been effaced to give the ECHR's territorial clause a depoliticized kind of tenor. Right? And what this discretionary territorial application clause did was to enable colonial powers to deny the scope of civil and political rights to overseas territories, because it was evident at that point of time that giving civil and political rights to colonized peoples under a regime of conquest was possibly a dangerous proposition, right? Because on one hand, it would lead to a barrage of individual petitions of human rights violations coming in from these colonial territories. Right? So naturally, the colonial powers wanted to evade that kind of scrutiny over their repressive techniques of governance which they had adopted in their colonies. Right? And yeah, the other argument which was made in the drafting process of the ECHR by the colonial powers was that the colonies are not ready for the enjoyment of human rights. Again, a very historicist argument which relegates colonial people, I feel, to the waiting room of history. Right? So that's an argument which post-colonial scholars also make. Right? And the colonial clause was therefore portrayed as something which is benevolent. It is benevolent in the sense that the people of the colonies had to be prepared for honoring their demands of self-governance which they had raised with the colonial administrators. Right? And paradoxically, the European powers, many European powers like the UK, had also argued that we cannot impose a treaty without the colonizer's will or consent. Right? Paradoxical, because again, what amounts to consent under a regime of conquest is itself very much questionable and contentious. But remarkably, the ECHR also had a rights derogation clause, which was kind of an auxiliary safety valve. So in case the ECHR is made applicable to, if the territorial application clause is used for making the ECHR applicable to the colonies, the alternative route to evade scrutiny would be the rights derogation clause. And when it comes to the ICCPR, that's what we see, that the fact that the rights derogation clause, or the emergency clause, that is more popularly known in Article 4, was allowed to be weaponized for evading scrutiny, if I may put it that way. Right? And so what the territorial application clause of the ECH ultimately did was it inaugurated this culture of impunity by limiting the jurisdictional reach of the ECHR. And when an international Bill of Rights was being proposed, it was proposed by the Third Committee of the General Assembly and ultimately affirmed in our General Assembly resolutions. Right? The scope of such an international Bill of Rights was made applicable to, I'll just try to wrap it up in a couple of minutes, if I may. So the provisions of the ICPR were proposed international Bill of Rights were made applicable to all the signatory metropolitan states as well as all territories, be it non-self-governing, trust, and colonial territories. Right? And Britain, in fact, threatened to delay its accession to such a proposed international Bill of Rights and flagged constitutional difficulties in light of such proposed universal application. And interestingly, when the ICCPR was adopted, we see a right to self-determination. We also see that the non-discrimination mandate is made applicable to territories under the jurisdiction of the colonial powers, the metropolitan powers per se. But Britain had also proposed an all-pervasive derogation clause, right? And it was only with the intervention of France and some of the third world states that a set of non-derogable rights were added to this right to the emergency clause. But what this emergency clause ultimately did was to create this securitization paranoia in the colonies. So all anti-colonial resistance and independence movements were therefore portrayed as a law and order problem, right? So on one hand, the rights derogation clause gave a veneer of legality to the repression in the colonies. And on the other, it also offered a kind of breathing space for colonial administrators to suppress independence movements, right, and freely exercise the monopoly of violence that it had. And coming to the concluding part now, and I'll just wrap up in a minute, right? More recently, we have seen the emergence of R2P, or responsibility to protect, as an avenue for jurisdictional internationalism. So we have now, I believe, come a full circle from evading obligations over human rights to now instrumentalizing human vulnerability as a possible cause for intervention. And R2P, as we know, is already something which has been affirmed by the General Assembly when the World Summit Outcome document was endorsed. Right? And what R2P inaugurates is a new lexicon of sovereignty, where sovereignty is recast as responsibility to prevent further human rights atrocities. And it delinks the question of human rights enforcement, actual territorial control, which is exercised by sovereigns. So you now have an exercise of jurisdictional authority, even in the absence of territorial control. So that is where this anti-catastrophic dynamic of human rights law comes in. Right? And in effect, the R2P reeks of the same civilizing impulses of the colonial encounter, which the likes of Anthony Angie and other third world TWAIL scholars have elaborately spoken about. And what R2P does is, provide for this supervisory jurisdiction, which and offered has equated to the spiritual prerogative of the papacy in medieval Europe, even before the Westphalian states had emerged. Right? So in effect, it refines this savior complex, where you allow for the Security Council, the collective intervention of the Security Council, and resultantly victims have no agency and are merely victims of violations in the global south have no agency. They are looked upon as acquiescent beneficiaries of this R2P, right? And yeah, so the Global South resultantly is merely viewed as a laboratory for universal human rights standards to be enforced. And that is where the savior complex also comes in, where if predatory state dispensations are, kind of orchestrating human rights crises, then there is a possibility of external intervention by a certain set of humanitarian actors. Of course, they can weaponize this form of intervention by installing friendly regimes, by installing friendly regimes which subscribe to a liberal democratic model, which are amenable to the interests of a transnational capitalist class, and so forth. So the final point which I'd like to make then is the post-colonial present of human rights discourse therefore continues to bear the taint of the colonial encounter. Right. With that, I'd like to conclude. Thank you.
Thank you so much, Rongeet, for that very rich account and for grounding your work in this kind of genealogy. We'll take up the rest in the Q&A session. And we finally have Priyansh, who's going to talk about the exercise of jurisdiction in low Earth orbit and the kind of territoriality that kind of exercise of jurisdiction possesses. I have to admit, I did not know much about this until I read your paper. This was very informative for me. And I was happy to see some of the interesting principles invoked, and we learned a lot from your work. And over to you. Sorry, your screen froze for a second. Over to you. Thank you.
I just want to make sure I'm audible and visible.
I think your connection is a little alright. Yes, try speaking now.
Okay, just am I visible and audible?
Your voice is slight break to it. Otherwise, it's fine.
Okay, just do you just give me 30 seconds? I'll try to fix this from my end.
No, I think it's okay now. I think it's okay now.
Hello. So should I begin? Yes.
Is it clear for you?
First of all, thank you, Professor Rohini, for that heartwarming introduction. And I must say that being here is truly a privilege that I don't take for granted. I'm sorry, am I audible?
Yes, you are.
You
yes,
are audible, but there's a slight lag between your audio and video. But do carry on. If it poses a challenge, we may have to request you to switch off the video. But I think for the time being, go on.
Okay, certainly. Just let me know if there's any problems with the same. So a good morning, afternoon, evening to everyone from wherever you may be joining us. So just to begin, I have chosen a rather eccentric area of law when talking about jurisdiction, which is international space law, since the first principle that anyone learns relating to territoriality or jurisdiction in space is that, look, there is no territoriality. There is nothing per se to exercise. And my goal with this paper was perhaps to have a radical reimagination of what we understand by jurisdiction and territoriality, and perhaps launch the research agenda into the stars, if I could. Now, the central argument that I deal with is the way the global north and the first world exercises jurisdiction in outer space, despite of the fact that there is no territoriality, that there is nothing to actually claim. There's a kind of jurisdiction without territory that is constituted, as Professor Chimni highlights in his article. I make this conclusion based on two ideas and two burdens that I create. First is that this exercise of jurisdiction by the first world creates a certain kind of disadvantage for the global south, because it creates certain entitlements and a certain power relationship between this first world and the third world. Second claim that I make, extending the former one, is to say that because of this power relationship, one, the reason it exists is because of the colonial advantage that individuals have had, that it further reproduces. To perhaps put my conclusion in a more formal way, my argument is that a certain exercise of jurisdiction is produced and reproduces neo-colonial relationships as we see in the modern era. Now, with this context, I think I first want to address how I built off this thesis and this kind of area from Professor Chimni's article. And I think the topic and the premises, the ideas that really resounded with me was the simple idea that territory is a social concept, and that there is a need to not see territory as being a concept that is bound by corporeal categories, by corporeal boundaries. And what is important is to assess if there's a certain power relationship or entitlements that exist. And the reason I think it really falls in me is because I think the primary view, the most fundamental idea of jurisdiction relates to us having a certain kind of entitlement, having a certain kind of power over other states, being able to dictate how institutions should be framed, how rules and policies should be made. And I think with this, the conclusion about how it leads to such exercise of jurisdiction, how it leads to a critical loss of policy making and the spaces that for third world have, which is also a point I explicitly address in my paper. And I think what really helped me connect these ideas was also Anne Offord's piece on extraterritorial jurisdiction, where she first explains that territory and jurisdiction was assumed to have an intrinsic link, where you only have jurisdiction because you have territorial control over such entities, over certain area. But as we see with the rise of rights such as the right to protect, we see manifestation of territoriality in other jurisdiction. And on a fundamental level, the way Offord puts it is that jurisdiction becomes a matter of specific circumstances in which a particular authority can have superseding legal entitlements. And this is the definition I go by. So I do undertake this analysis to reach to two conclusions, basically to distill my burden that I need to assess or I need to satisfy to actually demonstrate that there's a certain kind of jurisdiction without territory in outer space. First, it is to demonstrate a power relationship. And second, it is to demonstrate that this power relationship has an intimate connection with how colonialism and capitalism functions. Now, before I deal with these specific arguments, I think I just want to address the relevance of my research agenda. Why at all is it important to look beyond earthly frontiers when we clearly have so much that is. Now, obviously, my conclusion is that territoriality exists in space law, but why is it important to infer? First, as I also I began my presentation with this premise, is that outer space is seen as a space in a spatial sense where ideas of territoriality and sovereignty simply do not exist. The way layman imagines the spatial construction of outer space is just a simple void where entitlements cannot at this point. There has been a lot of discussion in policy discourse around how territory is being claimed on celestial objects. For instance, we all would have read about the criticisms that Artemis Accords, for instance, received for promoting national appropriation of mineral resources on the moon. Now, my thesis goes beyond this. I do not hinge my analysis on a newer kind of territory, which might be celestial objects or the minerals we get. But my idea is simply to look at the outer space. What is it that's happening there? What are the power relationships that have been constituted? And what can we learn about territoriality from simply that? And I think the reason I try to have this kind of radical imagination of what territory looks like, because if you look at the research agenda that we're trying to fulfill, either through the symposium or through the special issue, is to move away from a narrow and limited understanding of territoriality. And if we see space right now, there has been large amounts of capital being infused in outer space. It is assumed that for any developing country to reach that next stage of development, what is important is a big space mission. The new space where private ventures into outer spaces have become astronomically large. And the idea here is that if there is some exercise of territoriality in outer space, it's important to address that, because that is clearly a direction, whether we like it or not, our developments are sort of leading to. And space policy making is also a space right now which is currently underdeveloped, and we will see it change in the future. And I think this therefore becomes an important time to have these discussions. Now, before I move on to my specific arguments, I think I just want to take half a minute to explain what are the seemingly neutral rules that govern jurisdiction in outer space. Now, the most important rule for that is Article 8 of the Outer Space Treaty, which simply solidifies the flag principle in outer space and says that any space object which is registered in a certain country, that country will have jurisdiction and control over that space object. And the definition seemingly is neutral. It's similar to the concept of high seas, where we believe that no one can claim the high seas, but you simply have entitlement over your ships. However, as I wish to demonstrate, which will be the final thrust of, which is the primary thrust of my argument, is that because of how space functions on a technical and political level, the way power is exercised, the way this jurisdiction is exercised becomes important to note. And it is in this exercise that we can see a certain reproduction of neocolonial relationships. So I begin my argument with a brief observation on the common heritage principle, because this is something which has been solidified in outer space through Article 1 of the Open Space Treaty, which is supposed to be an in principle guarantee of distributive justice for the third world states. And this is very important because as the drafting history of OST makes it clear, the international community actively attempted and deliberately attempted to divorce themselves from older ideas of imperialism and colonialism. And therefore, Article 1 was inserted as a guarantee, which is to say that we won't repeat the same mistakes. But as we see with the common heritage principle in the high seas, where even though there is some agreement in the fact that the principle has a moral grounding, which was especially apparent after Arvid's speech in the UNGA, there is serious disagreement over
Priyansh,
concrete
Priyansh,
stipulations and its
Priyansh.
substantive from sea exploration while develop. Yes. Yeah, I can hear
We
you.
lost you for
I
a
can hear you.
good, yeah, we lost you for a good 10 seconds there. Your camera was completely frozen. Maybe you could do the reminder of his speech while keeping your camera off.
Okay,
Sen had
okay,
also
okay,
requested
okay,
audio with your.
okay, sure. That would work.
Thank you.
Am I properly audible now?
It's perfect. It's perfect.
Okay, so I think that I'll just begin where I started explaining my primary argument and how I take off from common heritage, the principle of common heritage, which is solidified in Article 1 of the Outer Space Treaty. And I think my point in brief was that while we have this in principle guarantee of distributive justice, it clearly in the past, we have seen it not play out in practice. So when we look at outer space, when we analyze the power relationships there, what is the difference between this principle guarantee and what is happening in practice? And how much does this legal, seemingly neutral guarantee live up to? Now, moving on to my point on why certain power relationships exist and why a certain disadvantage is created. To explain that, allow me to paint a picture for you is what kind of situation this specific point of time that I'm looking at. We are looking at a situation where there are record-breaking numbers of satellites in outer space, specifically the low Earth orbit, which is why I focused on it. And note that this congestion in outer space is really an incredibly big concern, especially now that we have multiple mega satellites project by, for instance, Starlink. Now, what it primarily does is that it complicates the concern of space debris, which is probably one of the biggest environmental concerns in outer space and for space exploration. To illustrate, note that a piece of debris with a diameter of 1 millimeter can completely destroy a satellite due to high velocity it moves around within space. In fact, there is something called the Kessler syndrome, which was originally identified in 1976 by Donald Kessler, which stipulates that if there is a certain level of density and congestion reached in the low Earth orbit, a single mishap, a single exploration can exploding of a satellite can lead to this domino effect where more satellites break away, creating debris and further affecting satellites. This is seemingly a catastrophic situation where any kind of space exploration becomes impossible because we cannot enter into space because of the debris. Now, there has been a lot of studies which say that the congestion that we are currently reaching at is very close to what Kessler assumed, and that we might be reaching, we might be sort of in a time period when this is something we need to seriously consider. Now, I realize that this explanation has moved away from my central thesis and a TWAIL-based discussion. So allow me to reel it back slightly. Now, what does this whole situation do? When there is space debris, there's a huge problem to any kind of space exploration, and it's mostly navigated by the principle of due regard under Article 9 of the OST. Basically, if a state launches a satellite in outer space, I, as that state, have the duty to ensure that it does not collide with other space debris or with other state satellites. I'm supposed to consider the present risks in outer space and move from there. Now, what it ultimately does is it gives entitlements to certain states that exercise jurisdiction in outer space through their satellites. And this is even more so when states have multiple satellites covering a majority of percentage of the entire space of LEO, which is it can give them entitlements over this entire area, which in my understanding leads to some extent a formation of a imaginary territory or a jurisdiction without territory. In fact, last year, USA and China had a diplomatic tussle about the same thing. And I think the conclusion that we reach is that global north, as we can look at outer space right now, will have much larger entitlements to the space in LEO, and which only exists because of the colonial advantage their space missions had. And it also gives these first world countries a larger voice in policy making. For instance, when we look at UN COPUS, the UN Committee on the Peaceful Uses of Outer Space, for decades, scholars and scientists from third world was denied a position in the UN COPUS because of insufficient scientific production, which, as we note, is because of the sort of power relationship that exists. Now, on my final point of how this relates to colonialism, we need to look at what this disadvantage actually results in. And I will specifically focus on how that leads to a kind of capital extraction of capital surplus. Now, one text that helps with becomes a starting point for my analysis is by Victor Shamas and Thomas Holin, where they use David Harvey's theory of special fix and explains how capital accumulates in new geographic terrains and extracts surplus from there and sends it back to their home capital. Now, this is something which is ever present in the LEO, which manifests in many ways. Surplus capital, which is vital for many activities, from weather extraction and defense intelligence, is extracted through data collection, satellites that are capable of that. And then the third world, who does not have enough space, enough ability to explore outer space because of the disadvantage they face, they have to rely on the first world to get these resources. In the space age, where using these space-based capabilities is necessary for economic and scientific development, the third world states are structurally coerced into subscribing to and getting reliant on the first world. And if they do not do so, they are left behind in the global race to develop. With that, I think I will conclude. That is all I wanted to share. And I think before I end, I just want to say that this was a very meaningful experience for me. And it would have not been possible if it wasn't for behemoths like Professor Chimni, who share their ideas with us. And I am only here because I stand on the shoulder of giants. And for that, I'm truly grateful. Thank you.
Thank you so much, Priyansh. Your paper has taken us to many interesting spaces, no pun intended. I was very happy to see the CHM principle invoked, which in and of itself, in many ways, even in its most generous interpretation, is a jurisdictional reach. We are now open for questions from our panelists, and then we move on to the participants. The floor is free. Anyone can jump in. Thank you so much for those wonderful rounds of presentation. Professor Chimni, do you have a question for anybody? Comment, observation, anything?
Yes, I, I do. In fact, I have one too many, really. But first, of course, I think you'll all agree that those were absolutely first-rate quality presentation. Each of these papers were extremely enlightening in terms of shedding light on different aspects of the idea of jurisdiction, the exercise of extraterritorial jurisdictions. So here are a few of the questions. I don't know how many I'll be allowed. But first, to Professor Atira Raju. She argued that the dual character or the dualism of modern international law actually helps understand the work of the ILO in the interwar period. And my question to her is, would she extend that analysis to the post-colonial era? So are there comparable insights that she she has to offer. Are there interconnecting sort of reflections that she may have? For Professor Maria Paul, thank you first of all for engaging with the piece. As you know, I very, very greatly admire your work, especially your pioneering book on jurisdictional accumulation. There is so much that I want to learn from your work and from your presentation today. But there are a couple of questions, and I don't know if it's possible to respond to each of these in the time that we have today. One is, of course, the first is, of course, trying to renew the sort of academic encounter, as you said, between international relations and international law. I was wondering how you look at the past episodes. So the first episode being the interwar period and the realist theory of the condemnation of international law, the deep skepticism about international law that Morgenthau disseminated, broke the link between IR and ILO as if it were. Then there have been many efforts. In the 90s, I remember Professor Anne-Marie Slaughter, trying to bring back this. And there was that reply from Professor Marty Koskanemi, who suspected that this was a hegemonic project where international law would be subject to the jurisdiction, as if it were, of international relations. So that was one question. The second question, which I found very interesting, is this is in connection that you made with Professor Swarnaraja's observation yesterday of defensive extraterritoriality. And I wanted to understand that. So in a sense, in the context that I define extraterritorial jurisdiction, I would imagine that some of the great sort of watershed developments in the history of the 20th century were moments actually of this counter-conduct that you said, of resistance. So for me, the October Revolution was the first point of resistance. Then came the decolonization. So in a sense, all anti-imperialist movements can be called resistance to, in whatever form, can be seen as resistance to this understanding of extraterritorial. But more specifically, I wanted to know what you had in mind when you invoke Foucault and his argument that to every instance of power, in a sense, there is a moment of resistance, that the two constantly go together. I wanted to understand what you had in mind. A third question that I had was, yeah, so again, that's a very large topic. I wanted to know your thoughts, but maybe you could, we could discuss this elsewhere. Your thoughts on my brief story about the emergence of capitalism and the modern state. We know that's a contentious ground. There are different versions of that history, and my whole idea was simply to offer a broad outline in the backdrop of which I could say the other things. So those were three questions. Then to Professor Poddar, again, a very fascinating presentation. So again, so you also talk in a sense about dualism. On the one hand, the liberatory, the emancipatory element of UDHR, and on the other hand, obviously, the legitimization of the colonial project and all that. And I still talk to my students about, by calling international human rights law Dr. Jekyll and Mr. Hyde. So in moments it is Jekyll, and the moments it is Hyde. So what would your thoughts be on international human rights law as it stands today? And finally, to Priyansh, I thought that was an absolutely great presentation. And when I was writing this piece, I was contemplating whether I should get into these. So when I wrote about the need to not have a fixed frozen view of territory, and also that jurisdiction exists without territory, I stayed with the multinational corporation because of its direct, because it's seen as a direct agent of capitalism. I thought, but the way you have extended that, the general thinking, contemporary thinking around the idea of territory, and sought its radical reimagination in this international space law, as well as law of the sea. Law of the sea itself is very, very fascinating. So I was wondering, what then you make more generally, more broadly, of the idea of extraterritorial jurisdiction? How do you feel? So I'm not putting this well. There's this mainstream understanding of what jurisdiction is, and then some of us are trying to challenge that understanding by offering alternative definitions, alternative narratives. I was wondering where you stand vis-a-vis that project. How much are you still with the mainstream, and how far do you go with the more critical project? My apologies for taking up so much time, but there's so much else in those very, very rich papers that I wish I could go on, but I know I've already taken up too much time. Thank you so much. Thank you to everyone.
You haven't taken up time at all, Professor Chimni. Thank you so much for those fantastic provocations. May I request the panelists to respond to them in the order they were asked? So we begin with Athira, then Dr. Pal, then Rongeet, and finally Priyansh. Athira?
Thank you, Professor Chimni. Of course, in the case of dualism in the post-colonial era, of course, it has been extended. We can see dualism throughout the life of ILO. It has never stepped back. But in the post-colonial era, we can see the emergence of, with the emergence of newly independent state. Though this state got more space in the ILO was again motivated by the Western, the ideology of Western powers, and they positively responded to the neoliberal principle promulgated by the Western powers. But in the post-colonial era, what we can see is that the line between the state and the laborers or the people is fading away. So it is no longer about laborers in the third world. It is about laborers in the whole world. And yesterday, I'm quoting Vinit's paper, that is Fourth World Approaches to International Law. So it's nowadays, recently, it's not about the third world states. It's about the people who are living in all the first world, and the third world. But in the post-colonial era, what we can see is that the line has faded, and because the third world state, become partners of. Like they started to respond in the same ways the Westerners has been responding. They started to adopt this neoliberal principle, and they have least concern for the interest of laborers who are in this country, and not only in this world but also in the first world. So I think that the dual idea is there. The dualism, International Labour Organization, has been following the dualist idea throughout its life. However, it's more siding with exploitation and subjugation. The liberation and emancipation is nowhere can be seen. And I have a criticism to all these post-colonial scholars, because they always opposes it, but they are not finding an alternate. They are not wanted to displace it. Though it is a one-sided idea, I know that yesterday there was, you were talking about the compromise all the scholars have to take, and it is a mess, and we have to go with this contradictory, this paradox of international law. But again, we have to find a formula to displace rather than always opposing it. So that's my statement. Thank you, sir. Thank you so much.
Thank you. Dr. Pal?
Thank you. That was extremely rich and generous of you as comments. So I'm not going to be able to cover, I think, the 3 questions, but I'm going to say maybe a little bit about each, especially the first 2, and the third one is definitely a bigger debate. We should have maybe under some other structure. But the relationship between international relations and internal is really interesting, and I've did a little bit of digging through these different episodes, my doctoral work several years ago, and more recently in an article actually I've been working on. But as you said, the interwar period starts with, international relations is created by international lawyers, right? So there was no international relations disciplines until quite early in the 20th century, and it was a very imperialist discipline in the way it was shaped in its early days, either very naively liberal or outwardly imperialist, and in a very racially determined way as well in the US. And in the UK as well. But what we have then, as you said, with Morgenthau in post-1945 discipline is a rejection of that. And it's a joke because Morgenthau was an international lawyer. He trained, his PhD was on international law, and he knew exactly what, he understood it very well, but the separation of law and politics was fundamental to develop a scientific approach to international relations. And so the discipline of political science develops in the US as an episode. So for me, that's this difficult encounter that defines itself through the other throughout the 20th century. And the fact that international relations it's a magpie discipline. It steals from all other disciplines around it, really, and it struggles to find an identity, and still do. A lot of, I think, people who are critical in international relations don't want to be associated with international relations too much. They do international political economy, or they do critical theory, or so it's a difficult beast. But I think to come to the last episode you mentioned, which is the most recent one in the 1990s, Slaughter and Co., liberal institutionalist project, which obviously has less of a voice today, but maybe I'm not enough in those circles in the US. So I'd be happy to be corrected on that in terms of how much influence it still has. But my sense is that it's being less discussed, and there's still a strong discussion of norms and global governance and processes of constitutionalism in many ways in the discipline of international relations, which links back to that sort of connection. But I think the impetus of critical approaches, and especially in international law, and of the critical histories of international law, has done a lot to displace that project. And obviously, Marty Koskaniemi's very funny and sharp letter to Slaughter and Co. in the symposium we're referring to, I think did a lot to damage that project, rightfully so. But that doesn't mean we shouldn't try and think of these two disciplines and their connections. And I think it's happening more organically now. And I think a lot of people, maybe myself included, even though I'm more of an IR person, just see ourselves as in between the cracks in many ways, but organically also shaping something, a new sort of encounter. And I think especially your recent article does this, is part of that in a way, that trying to rethink organically what the origins, the genealogies of those disciplines. So I really think that's key in terms of rethinking how those disciplines are intrinsically connected. On the defensive offensive, this is a very kind of sort of fresh thinking from me just since yesterday. So it's sort of I need to think a little bit more. But what I want to capture with counterconduct is what I think we've discussed before in terms of how do we think of extraterritoriality as something positive, as something that can be captured, as a form of resistance? And I go back to Rob Knox's concept of principled opportunism and trying to think how we can strategically use the law. Right. And in that sense, we need to be aware of its limitations. And so if we think of the attempts by human rights organizations, by, for example, the Maastricht principles, which I think you talk about in your article, as opportunities to strategically capture obligations, extraterritorial obligations, as a way to make states and corporations more responsible, that for me is a process of counter-conduct, because it can only go so far in the system that we have. I think the examples you raise of the October Revolution, decolonization, those are bigger projects. I wouldn't put them as counter-conduct. I think those are significant projects of reshaping the international order. So I think there's a difference between those and the sort of Maastricht principles projects. So that's where I would maybe put the counter-conduct. And the emergence of capitalism, well, yeah, it's such a big question, so I may leave that and leave space for the other, because maybe I'll come back to it later, or hopefully we'll organize something else about that.
Thank you so much. Rongeet, your turn.
Yeah, thank you. Thank you, Professor Chimni, for engaging with my paper and offering such enlightening comments. And with regard to, so I particularly like the fact how you refer to the International Human Rights Project as having this dichotomy, or having this Dr. Jekyll and Mr. Hyde kind of feature, right? And my understanding is that the Human Rights Project does have certain emancipatory elements, but as I've already pointed out, it does, as you also have pointed out, it does legitimize this colonial project. So that duality is something which we also see in operation today, particularly in the context of how things are about the unfortunate state of events in Gaza in particular, that this duality very much remains entrenched. But I also have a couple of observations regarding what this duality has transited to at the domestic level, percolating from the international level. Now, I'm not very optimistic, or in fact, I am particularly disappointed as to how post-colonial regimes have embraced this coloniality at the heart of human rights, right? So I would like to call it like an inheritance of coloniality, right? Where ruling elites in the post-colonial world have inherited the colonial dynamics of the human rights project, and which is perhaps best visible in how these ruling elites have weaponized the doctrine of emergency in many contexts over the last few decades. And I find this a paradox, because in the drafting process, you had the state representatives of the likes of Chile and Lebanon, and so many third world states being very critical of rights derogations, right? Arguing that rights derogations, despite the perfunctory, checks and balances apparatus that Article 4 has, that it is subject to abuse. That the fact that we are inaugurating, and the fact that we are entrenching this idea that human rights are indeed dispensable, right? That itself was attempted to be problematized in the drafting process, right? And I would attribute this coloniality of rights derivations to this more modern concept of undeclared emergencies, or emergencies without formal proclamation, which by which I mean that the system of checks and balances under Article 4 have been completely done away with, right? So with the intercession of France and some of the third world states, Britain's proposal had been completely, I would say, rejected, right, of having an all-pervasive derogation clause without any set of non-derogable rights. That was completely rejected, right? But despite that, we see today how post-colonial regimes have been weaponizing the idea of emergency, and perhaps post-globalization and post the fall of the Soviet Union, I would say, we see how human rights is becoming more and more market friendly, how the idea of human rights is perhaps being diluted, right? And rights derogation, or the very idea of emergency, has become a tool I would say, discipline the working classes, right? So ruling elites in countries like my own country, but they are in effect they have collaborated with the interests of transnational corporations and the interests of capital in general. So I feel it's very difficult to uh, build a counter hegemonic solidarity today in the human rights project. And with these two observations, I'd like to conclude and I'm open to more questions as well. Thank you.
And our final panelist, Priyansh.
Am I audible? If I'm not, I can just switch on my video for now.
It's working well. Go ahead.
Okay. So I think I just want to qualify any response I give. Really, I don't think can be compared to what has been said earlier. I simply lack the volume and amount of knowledge that perhaps my co-panelists have. But I think what Professor Chimni asked me, which is to say that where I as a student stand, and I think that's how I'll try to calibrate my answer, because in all honesty, extraterritorial jurisdiction, unfortunately, it's not something I've had the opportunity to read through and make more concrete opinions. And I think the way at least I consume information, I'm very critical about committing to a position without knowing enough. And I think I'm in a fix right now. But I think what I can do is, because I've always obviously had the privilege of reading the pieces in the special issue by like Professor B.S. Chimni and by Professor Sonaraja and even by Professor Chimni, who has dealt with extraterritoriality. And I think I do have some views about it that I would like to share. So I think what spoke to me the most, which made the most sense to me, was Professor Chimni's explanation in a final section, which concerns finding common ground with Professor Chimni's argument, which is to say that it is important that when we discuss universal jurisdiction, we do not see it in a unilateral way. It's very important to understand that these kind of jurisdictions must be treated differently. And I do admit that the examples that she adduces and that Professor Sonaraj adduces should force anyone to think about if we want to completely divorce ourselves from any exercise of extraterritorial jurisdiction. And I think even though I find this sort of explanation of how we should look at the discourse satisfying, it also makes me slightly uncomfortable, right? Because the larger question of, as a principle, do we want states to have that kind of entitlement, have that kind of control, and what the consequences it will reach to be consistent in answering this question? We really do not have I personally think that we do not have the privilege to pick and choose what we like and what we do not like, unless we can be theoretically crafty enough to find some kind of a consistent justification to say this kind of jurisdiction is correct, this kind of jurisdiction is not correct. Now, as to, I think from my limited information, where I stand is, I would say that I will be suspicious of extraterritorial exercise of jurisdiction, and two reasons for that. First, I think Professor Chimni's analysis, which sort of concretizes the premise of how just the very exercise and the concept of extraterritorial jurisdiction can be linked back to a very direct, very deliberate attempt by colonial forces to sort of maintain their hegemony, expand their power, extract capital surplus. And I think, and especially this also connects to my paper, the way I imagine it, I tend to assume that when extraterritorial jurisdiction is exercised, the more powerful state who has the benefit of colonialism on their side would be able to, in a way, oppress the third world states. And this kind of extraterritorial jurisdiction will allow them to sort of be able to do this anywhere they want. And therefore, at least this is how I see it right now. It might be very different, so to say, but this is why I would say I'm suspicious. But I think it is important, especially as scholars, as policy makers, to face the uncomfortable question of there being benefic uses of extraterritorial jurisdictions and committing to sort of a kind of doctrinal and theoretical inquiry, which helps us reach a more consistent understanding of what kind of extraterritorial jurisdiction to allow and what to disallow. Yeah, that's it from me.
Thank you so much, Priyansh. On that grounded note, we shall take a break, after which we will resume our open discussion and we will see everyone on the other side. Thank you so much for joining us.
Well, welcome back to many of you. And for those of you in the general audience as well, thank you for your solidarity and for being with us through these, very interesting conversations. That was noted before the break, could well go on for much more than another half hour. But I think we will take about 25 minutes now to open up for broader discussion and invite members of the general audience to add questions using the Q&A function if you are so inclined, and then for our contributors to use the raise hand function if you have things you would like to say. And to start us off, I'll turn over to Bharat Arjun, who has been a stalwart supporter, initiator of this project, and I think he has some questions also for Professor Chimni to begin with.
Thank you, Shimon. So I thought a fitting note to start the open discussion would just be to revisit where we started. I've personally had a chance to read Professor Chimni's article multiple times during the conceptualization stage and seeing how it would fit with a lot of existing scholarship and research interests. And I found myself thinking during the last panel that, Professor Chimni, so many people have had so many different takeaways from your article. And I understand in many ways that your intention was also for it to be a conversation generator in that space. And we've seen people, for example, some Maia drafted a new research agenda on the basis of it. We've seen a couple of lines of space law being taken forward and starting a conversation there. And we've seen Professor Scheiman's own response to it, which attempts to find some sort of a middle ground. So we thought a good note for us to start this off would just be to ask you, on the basis of all these takeaways that many different people have had to your publication, maybe your reflections at this stage, any additional reflections you might have had now that we are at the final stage of the symposium. And I was also hoping that post that Professor Scheiman could also chime in, because both of you have been very patient listeners. Both of you have taken a step back, listened very carefully to all of us, have posed very interesting questions. So I think it'd be great for you both to take the center stage and then move on into a proper open discussion amongst all of us. Thank you.
You're still on mute, Professor Chimni.
Sorry. No, I was just going to say that can I request Professor Keitner to take the floor first? Because she's been listening the most patiently, and her contribution to bring this project to fruition has been enormous from what I gather. So can I request, and I'll follow her with my reflections.
Well, I'd be happy to, but I also very happy to defer. I mean, I just want to express my gratitude to everyone for this collective endeavor, and again, reflect on the themes that Rohini brought at the beginning of our conversations yesterday. In particular, how non-hierarchical I think it has been, which, I think we've even all gone back and forth between addressing each other with honorifics and without, and I'm still not quite sure which I'm supposed to be doing. But I think that that's a reflection of the ways in which, we have, I'm very proud and grateful to say, I think, managed to create a space for conversation that, as we all know, spans, multiple time zones, which we can do now with technology, even if the signals are running through undersea cables that are as Maia told us, probably not being managed in the most democratic way. And so just for us to have the opportunity to share these ideas. I mean, I was so struck by this student initiative with the original board of the National Law School of India review, where they reached out and did the research on their own, really, to come and find this magnificent article that you had written, Professor Chimni, in the Leiden journal, which again brought me back to my student days, and even hearing now some of the ongoing conversation about Anne-Marie Slaughter's work. In fact, I think just today she published an op-ed, which, she's been running a think tank for many years now, after having both been, of course, in academia and then at the State Department, where I also spent a brief amount of time. And so also seeing the ways in which our own academic training, and it's been delightful to have students on as part of this project in many ways, as editors, as contributors, as audience members, and who have given us wonderful questions over these last 2 days, because I think we are very much shaped by our educational experiences, but also hopefully not limited by them. And so, for example, in my international law classroom, I would say that I probably take a more mainstream approach. I think Shreyas, who is now shepherding this volume through to conclusion, indicated yesterday that may tend to be his orientation a little bit more as well. But I've also really endeavored to incorporate more critical perspectives, to encourage my students to recognize the messiness, to use a word again that I used yesterday. And I think one of the things maybe that I come away with is, just an understanding of the multiplicity of actors and the different motivations that those actors might have. So I think, Professor Chimni, one of the pieces of your article that jumped out at me, just because this happens to be, an area of study of mine, was I was interested to see what I perceived to be your rather more favorable view of, for example, the U.S. Supreme Court's decision in the Kiobel case, which, I think was animated by the fact that more and more defendants in these alien tort statute cases were corporations. And quite frankly, to circle back to Kaliki Mehta's contribution from yesterday about corporations and the environment, there are a number of NGOs in the US and elsewhere who were trying to use the jurisdiction provided under the Alien Tort Statute to advance a pro-environment agenda. And that was really shut down. At the same time, I do think it's absolutely critical to express concern about the ways in which either universal jurisdiction outside of the ATS, for example, prosecutions under the US torture statute, have been selective. And so, as we heard just before the break, I think all of us as academics and citizens sort of vacillate between wanting to have some sort of clear, principled approach that would answer every contingency, and hesitating to adopt too much of a case-by-case positionality, because it does seem quite susceptible then to inconsistencies and sort of subjective assessment. At the same time, if we do have a categorical bar, then it could deprive some claimants of the opportunity to seek redress when they don't have redress in their home countries. And so perhaps two themes that I think have been coursing through this 2 days of discussion would be that, one, kind of the search for consistency and the ability to articulate broad principles of general application, and the messiness that sometimes calls for a more case-by-case approach, and the extent to which different people may have an orientation that seeks more the principled bright line rules, and others maybe more the kind of messy, but then perhaps more subjective approach. And the other certainly has been this distinction between states and peoples. I think that came up both yesterday and today, whether we call it fourth world approaches or the ways in which, colonial states, Professor Sorna, of course, also emphasized this yesterday, have in turn become in various ways, oppressors as well. And so does this mean that we need to think beyond or even dispense with the state system that, seems unlikely in the short term, but I do think we are seeing a lot more transnational activity of various sorts, and both solidarities and also more pernicious transnational forces, but certainly to pursue I think of it maybe as a TWAIL sensibility rather than necessarily a TWAIL agenda, but one that seeks to look beyond the doctrine, as you have long encouraged us all to do. And if we all come away with slightly different personal sort of agendas and research projects based on that sensibility, I think that's just a tremendous contribution, and I'm honored to be a small part of it.
Thank you so much for those remarks and observations. I'm sure the NLSIR editors are ever grateful to you for being part of this project. And as I said yesterday, I'm also extremely grateful for your engaging with my engaging with what was essentially an exploratory essay. As you rightly sort of said, this the map of jurisdiction and its exercise is a very complex map, and that's why I said in the beginning of my article that a certain amount of generalization and linearity are part of how I present the materials. But I'm quite aware that the actual picture is much more messy, and that it is very and that there are gray areas which need to be explored much more. And I would readily concede that. As I said yesterday, my project was to try and trace the trajectory of the exercise of extraterritorial jurisdiction over time, especially from the 19th century, and try and see how it shaped, how it impacted the global South nations, both in the colonial era and in the post-colonial eras. And in doing that, perhaps I came across as someone who assumes a rejectionist position when it comes to the possibility of using contemporary practices in different jurisdictions to the advantage of weak nations and to the advantage of subaltern groups. And it is true that there have been moments in US courts where it has given decisions which one can't complain, which one can't complain about. In fact, I don't know if the students are aware that I've often been branded a reformist. Among those who do offer a materialist understanding of international law, they're supposed to be reformist, and those who are in the constitutional law sense debate, originalists. So I'm reformist, along with probably I've been put along with Professor Susan Marks and a few others. And the reason I mention that is that that reformist impulse in me seeks to balance the possibilities, and is aware of my own reading of Marx and the subsequent iconic figures is also that at no point of time they rejected the use of legal means in whichever jurisdiction to advance the cause of the working class, to advance the cause of the subaltern classes, and So I don't know whether I should proudly say I'm not proud of the fact that I'm a reformist, because I'm reformist in a particular sense. That is, as long as the reform process in some way encourages or propels us in the right direction of change, it is acceptable. But if the reform process is one which legitimizes the current unequal order, then it's a problem. So the category reform itself, and I think Professor Robert Knox has contributed very, very significantly to that debate. But that's a larger debate. Only, as I said, the reason I mention is that's why I go along with your idea. But because in that article I was more concerned with the larger historical trajectory, and as Professor Pal said, trying to work out the theoretical sort of way, the theoretical representation of that material, I did not. The other is that I'm trained in India. So my understanding of jurisdiction like the United States is limited, I must confess. I don't fully understand how it works. And that's so the whole spate of inadequacies, but that's one inadequacy that I must confess, that I don't fully understand how for example, the exercise of universal civil jurisdiction, it has a complicated history. There are ebbs and flows, and so that history, well, I tried to grapple with it, but I'm not sure if I really fully, and that's why I'm hesitant to say anything very firmly. But I have no issues with using any jurisdiction, wherever it is, if it works in the interests of the global South states. And the final comment is, I entirely agree with, in a sense, with Professor Swarnaraja, that we need to look inwards. And so that is, as you know, and that's part of the problem of the mainstream. The mainstream international law, even when it talks of the logic of territory, treats all states alike. So because it doesn't talk of the logic of capital, it doesn't talk about the nature and character of different states, which need to be factored in if we have to discuss about the, if we have to look inwards and look at the oppression of the global South states. But in my own work, I try to capture that by talking about the emergence of the transnational capitalist class, which again is contested space. Many argue there is no such thing, but in my view, there is a transnational capitalist class which actually, in a sense, anticipates the future. So there can be a debate about whether at this precise moment there is a transnational capitalist class or not. But as Marx explained in Grundriss long ago, there are some developments which which presage the future in ways that you can underscore them. So let me conclude. But first, of course, great thanks to everybody once again. I just want to say my only ambition in writing this piece, or the other pieces I've tried to write on the doctrine of jurisdiction, on doctrines of international law, is simply to initiate a debate. I think the areas of each doctrine of international law has a long history, and of course the genealogical exercise. Again, the genealogical exercise, there is a Foucauldian exercise of genealogy, which is about destabilizing, stabilizing categories, and then there is the regular, what I call genealogical exercise, which is essentially a historical exercise, is very, very helpful. And the idea was to begin a conversation. I'm very, very aware. I've always been aware that we cannot capture this messy reality, through one piece or even larger work. But if it begins a conversation which takes us, as Priyansh was saying, towards an alternative imagination, towards setting an alternative research agenda, which is what I set out to do, I would be absolutely satisfied. And even that satisfaction is not always forthcoming in the academia. Even for an academic, it's not always the case. I mean, I've been working for decades, and I used to wonder who on earth reads me. For decades we didn't even know this. I'm a dinosaur, so I come from the pre-internet, pre-photocopying age, where if you wrote something, it just disappeared, and you didn't know if anybody read it. So even from that biographical perspective, this is a great moment for me, and I'm very, very thankful to everyone who's participated in it. And to conclude, let me reiterate, the whole idea was to initiate a debate, because we need to get away from the mainstream. About that, I'm certain. By not rejecting the mainstream, there is much to learn from the mainstream. There's much to understand why for a century and a half they dominate and continue to dominate the discursive space. So I'm not rejection, but I think we need to move on. And I think that's what is happening with not only the TWAIL, but with the feminist approaches to international law. It's an enormous contribution there, with critical race the theory, and of course, with new approaches to international law, with Professor Kennedy and Marty. All of them have contributed richly to creating this critical space. And I think for all of those who are interested in public international law, there is out there, which was not there in my times, there is so much out there as foundation from where you can, or resources rather, more than foundation, which you can actually draw from in order to take any of these projects forward. And the kind of talent that I just saw on display makes me feel that we are going to be able to transform the discipline sooner than later. Thank you all, and I hope you'll bear with my rambling remarks. Thank you.
I think that was inspirational, and it's slightly less of a dinosaur, may I say, but still some kind of prehistoric creature myself. I know this field is definitely in good hands with so many of the interventions that we've heard over the past 2 days. That said, is there someone from among the contributors who would like to add something else to this very rich discussion at this stage before we conclude?
I have, of course, I have my share of differences. As Pal said, she has a different take on the history of the. Likewise, I have a different take from Professor Swarnarajan, and we have been sort of going back and forth on questions of whether there is imperialism at all or not, and he's insistent on the use of the category hegemon. But my sense is, that we agree eventually on most things, although it would appear on the face of it that we don't share. So I have my differences, and but I think those differences are, not. Are not ones that call for attention, especially call for attention today. I think what struck me was this remarkable sets of presentations and engagement, and if we can continue with this, so that it's not a one-off event, that we continue with this, and from scholarship, both from the global north and global south, and continue. And NLS has taken, National Law School Bangalore has taken the lead, as it has done in so many other areas. I hope they can sustain this, so that it's not, so that this conversation can continue. It doesn't have to be a special issue or a symposium, but we'll have to find different ways and forms and different spaces also for continuing the conversation. For the rest, I don't think it would be a sad day if all of us agreed with each other. That would be a very sad day. What would we do thereafter?
Well, I agree that it's important to disagree. So there we go. And I was going to say, yes, we've so much appreciated your participation, Professor Sen as special advisor. So the Jindal Global University is well represented. Of course, the National Law School of India, Bangalore, that has spearheaded this and is carrying it through. And you'll always find a very willing partner and co-conspirator with the University of California, Davis, and the California International Law Center. So Rohini, why don't I turn it over to you then, if you have any, at this point, concluding reflections, and then we will turn it back to the students where it belongs for the last word.
Nothing from my end, honestly, just a huge thank you to everybody for making this happen. Those behind the scenes, we know for how long this has been going on and what sort of effort it's taken to get this off the ground. So I'm just very grateful to see this through. Thank you so much, Professor Chimni, for attending both days of it and engaging so closely. Professor Sonaraja, who's no longer here with us for the last session, and everybody who attended and couldn't join us on both days. The effort has been Herculean, and I think it shows through in the presentations, in the contributions. And the only thing I have to say is please read the special issue when it comes out. The contributions, as you've seen from the presentations, are absolutely brilliant, and it will definitely carry forward the conversation, the dialogue, and the debate that this text has set forth. So the afterlife of this text and the ones attached to it will be a long one. Thank you. Thank you so much.
Thank you.
If there are no further comments, I think I will be closing off the symposium with closing remarks. So shall I proceed then? Okay. So I'm going to take some time, around 5 minutes, to quickly wrap this up, because there is so much to be said to close this up properly. I think first I'd like to just begin with what the symposium has been. Yesterday we saw the symposium peaked at around 100 participants, and today we retained around 50. And I think that's great, especially by academic conference standards. As much as I've seen, at least during my law school time, these are probably record numbers. So we're very grateful for the participation that we've received. We're very grateful for people sticking around. We are very grateful for people who posted questions in Q&As, people who engaged each other even after their discussions were over, who are willing to be patient listeners to all. And I think amongst everything that has already been said, there is also very important reflection on what international law concepts can mean for us. So when I had begun with the conceptualization process from jurisdiction, it was purely serendipitous, because that was something Professor Shimon was interested in, and Professor Chimni happened to have written on. But a lot of people, I think, at that point did think that jurisdiction was fairly restrictive. But just to see the different ways in which this has been conceived by people, this has been reflected on by people, I think it's been fascinating. I personally have had a chance to read many articles and perhaps even weigh in here and there from the first draft stage to just see how many different perspectives that were brought in. And even as we saw within Professor Chimni and Professor Sonaraja, where they agreed on, where they disagreed on, I think that's been a fascinating exercise, because when it comes to international law, especially from the global south, we tend to see it A, from its origins, from its history, from its justifications, and B, where we converge with the mainstream understanding that is in enforcement and how it's been used, and theorization part of it. So just to see all these lenses come in has been incredibly special. So my hope again is that we do see international law come in conversation across geographical boundaries, across cultural barriers, and across theoretical underpinnings, to have a meaningful conversation like this, which is respectful and which is understanding and which is honestly very meaningful, is a hope that I think I will personally carry forward, and I hope that many further editions will carry forward. And coming to Professor Chimni as well, just your presence here has meant a lot to us. A lot of us have been inspired by your writing. We have read you in class, and a lot of these conversations we have taken forward. We have thought more deeply about thanks to your work. And even I remember when I was initially thinking of the specialist, I had spoken to my IL professors at law school, and both of them were students of yours. So just to see your legacy carry forward itself is special for a lot of IL enthusiasts in our country, and I'm sure in much of South Asia. And as Professor Shimon also tells me, across in the US and other spaces as well. So that again is something we'll always hold dear. And thank you for sitting with us for 2 extensive days of communication and conversation, and being such a patient listener and an active participant. And I think that is a good segue into what TWAIL has meant for us. And initially, I must admit, my own exposure to TWAIL was not that great, at a passing interest. And at that point, I could think of none better than Professor Rohini Sen, because she was just such an active participant in most of the conversations that we've had. And she's always been willing to understand at the rudimentary stage of that idea. She was willing to help me really refine the TWAIL and bring in her own insights, push my own thinking. And we've had so many conversations surrounding TWAIL through which I have been very informed. And she in general has played this role for so many of us in India, as a young scholar herself. And one thing that she does radiate a lot is genuine passion for this discipline, what IL means and what TWAIL means. And she's constantly told me that TWAIL is not just theory, it's a methodology, it's a way of understanding. She took a course at NLS called Ways of Seeing International Law. And I think she's someone who really represents what the symposium has come to represent, which is just that all of us, from whatever space we come from, the lenses through which we view international law, which we view discipline, and which we view pedagogy, and just for it to sort of converge in one point in the best fashion possible has been great to witness. And coming to Professor Shaivan Kidner as well, she has very tactfully underplayed a lot of her contribution to the cause. She's been very graceful to take the back seat and let others have the spotlight, including myself. But her contribution to this cause has been immaculate. She has always been more than willing to let a lot of us, especially students, take the driver's seat here, while she's always sort of guided us, again in very graceful fashion. Her suggestions have been extremely useful for this. I remember the first draft of the concept note, she had very gently told me areas where I think I was getting a little ahead of myself, and point me towards spaces which could actually create great conversation. And she's genuinely been a great mentor and one of the best guest editors I think NLSIR has had in many years. So we'll always, I personally and NLSIR as a community will always be greatly indebted to both Professor Rohini Sen and Professor Chimni. And the last reflection I have is also one of diversity in which I had begun my opening remarks as well. The specialist itself, the way it's been conceptualized, our advisor is a TWAIL specialist, and our guest editor is one of the leading voices of international law jurisdiction. I personally read a lot of her work to understand a lot of these concepts myself. And to see where we all agreed, where we all disagreed, what shape it eventually took, and then to see panelists come from all across the globe, many spaces, many different understandings, has been great. And again, Professor Shimon Keitner, like Professor Chimni also had mentioned, has been carrying this conversation ahead in the US. She took this forward in the American Society of International Law. And our collective hope is that, like Professor Sen mentioned, will be carried forth in many other spaces once especially she's out in print, which I'm sure Shreyas would do a great job of seeing through, as he has from the start of his takeover of the board. And lastly, I think this is also incomplete without giving a shout out to our ex-chief editor, Kopal. Kopal has also reposed her faith in a very young board, and she's always been in the sidelines guiding us, helping us with the logistics a lot, helping my own ideation, setting up a lot of these conversations that I've had the privilege to have. And this will remain incomplete without what Gopal Mittal as a person has contributed to this cause. And Krishano, the deputy chief editor, who was assisting her along with it. And lastly, the thing I want to speak about is also about India and South Asia and critical international law. One area where the special issue started with was that we did not have spaces in India where these conversations were being created. A lot of the publications that I saw which were fostering conversations were in foreign journals. And at that point, I remember thinking that if we could have a space like this in India, that'd be fantastic. And there are spaces which are coming out. I think Jindal is doing a lot of great work there. We have Indian Journal of International Law and a lot of other spaces. But just to bring critical legal theory in conversation to mainstream international law and sort of go past the binaries that these tags represent and come to a more meaningful space of conversation where we can have these disagreements out in the open and have understandings as well and have these debates come together. I think that's a fascinating project. And I think that's a fascinating direction where international law is headed the coming few years. And I hope that every person who's invested in this, every person who's attended this, spent a time with us, spent a deposit trust in us, have had something to take home from it, because I know I certainly have. And we look forward enthusiastically for the special issue to come out in print. And we are again very grateful for your support throughout, and we expect to see it continue then as well. Thank you very much.
All right, until we meet again, friends.